It seems like every case in the news recently has a political component to it. And the case that we're going to be discussing today with Lisa Wayne is no exception. She represented Jason Williams, the DA in New Orleans, and we're going to be talking about representing a client in a politically charged case, whether to call that client or not, how race plays into it, jury selection, the importance of opening statement, the importance of stressing beyond a reasonable doubt. It's a really cool discussion with a really cool person, Lisa Wayne, who runs NACDL. What I need you all to do to get the word out is to like, subscribe, review these episodes. It's really important. And I think you're going to enjoy this one. In For the Defense, we have Lisa Wayne next. My name is David Oscar Markus. I hope you enjoy. Thanks. Well, I'm delighted this morning to have the wonderful Lisa Wayne on the show. Lisa is not only one of the great criminal defense lawyers, but probably the coolest criminal defense lawyer that I know. And she is now running the National Association of Criminal Defense Lawyers. But before that, she had one last trial in her, the Jason Williams trial, which we'll be talking about. Welcome to the show, Lisa.
Thank you, David. And when you say I'm one of the coolest, we're going to have to do something about that. We definitely have to expand the scope of your cool life.
Well, that's a good point. That's why I'm hanging out with you. So tell our listeners who Jason Williams is and a little about the case.
So Jason is the elected district attorney in New Orleans and ran for election during the course of being indicted in federal court. He was a defense lawyer and had been in New Orleans for quite some time, and also was a city council person and had been an elected city council person for quite some time in New Orleans. A pretty popular individual in New Orleans.
You know, one of the things we're seeing around the country are these so-called progressive folks getting elected as DAs, prosecutors. Was he one of those progressive prosecutors?
Absolutely. He ran on a progressive platform in a city that is plagued by, allegations of lots of crime. But despite that, he was elected pretty easily for his first term.
Because I know you wouldn't represent any old prosecutor. It'd have to be a special prosecutor for you to represent him, right?
You know, I actually would represent anyone who is accused. I really believe in that. But with that said, Jason and I had been friends. I did not in any way donate to his election because I have some real feelings about this progressive prosecution kind of platform anyway. But I believed in Jason, and I knew him as a friend and as a person and as a defense lawyer. He and I had cases together in New Orleans prior to him running for DA.
Well, I was going to ask you, I mean, I think your roots are in Denver. You're in DC now, obviously. And this was a case in New Orleans. I'm always interested in how people get cases, especially out of town cases, but is it because you guys were close buddies?
No, I had actually done a couple of other cases in New Orleans with Jones and Walker, Mike Magner, and Avery Pardee down there, and Billy Gibbons. And so, my practice became, and a lot of that has to do with teaching, David, and lecturing around the country. And lawyers bring you into cases based upon what they see and hear about you. So I had kind of picked up this national practice anyway. And Jason, after I did a fairly well-known football player case down in New Orleans, Jason asked me to come in on a couple of cases down there.
Do you like doing cases out of town?
I do, depending on the town.
Right. No, and I've done trials all over the place too. I was just in Tallahassee for a month. I had never set foot in Tallahassee before, but there's something about trying a case out of town. You can focus everything. You don't have to worry about the phone ringing in the office. You don't have to worry about the family, and all those other things. You can just really focus on the trial, which I kind of like.
I agree with you on that. I think it has there's so many different variables. And frankly, I had incredible local counsel whenever I've taken on these cases. That makes all the difference in the world to me because, you're treated differently when you're an out of towner. And I think it's always smart to have a good lawyer as a colleague and a partner on these cases. And I've been extremely lucky because wherever I've been brought in, it's been top-notch colleagues. So that helps. That helps.
Yeah. Now this is pretty wild. I mean, the DA is charged. You're representing him. What is he charged with? And what court are you guys in? Are you in federal court or state court?
So we're in federal court. And so what happened is the DA that was in place at the time that Jason was charged is a well-known guy by the name of Leon Cannizzaro, who had a notorious reputation in New Orleans. And frankly, like most of the DAs in New Orleans, it has been a very corrupt, very harsh and ugly place to get charged with any crime. So Cannizzaro was in office at the time. Trump was the president during the election, and Jason was literally indicted on the eve of saying that he was going to run for election. So it happened right then. He knew it. We knew that it was coming down the pipe, but he was charged, I think, the next day after he had said that he was running for election. It was in federal court in the Fifth Circuit, and he was charged with tax frauds counts and 8,300 counts, which are not adhering to the law in terms of how you get money and how you record your money with the bank and with the feds.
So Lisa, I mean, he gets charged on the eve of announcing his campaign, and this is a good segue into one of the big pretrial motions you file. I mean, obvious political overtones to the case.
Yes.
And you guys file a motion to address that. Tell us a little about that motion.
So, there are two ways to go about this. There's what's called vindictive prosecution and selective prosecution. Both defense lawyers know very, very tough to overcome the law on both those angles. But we filed a motion on vindictive and selective saying, where were there other lawyers who are running for DA in this kind of county under these kind of circumstances, African American, and saying that this was clearly the reason for this was to get him out of the race, and that it was vindictive in terms of these were old tax counts, unfortunately not beyond the statute of limitation, and went way back when he was a defense lawyer practicing and had never been addressed, and he had never been given a fair opportunity to or notice on any of them. So that was a very involved motion, 99 pages, as you see. And it was very involved in terms of the litigation. What was interesting, though, about the case is that when Jason was first indicted, he was in front of a judge named Judge Feldman. Judge Feldman was actually the oldest federal judge on the bench at the time.
Oh, wow.
So it was really interesting. Judge Feldman, all of these judges down in New Orleans have these very interesting backgrounds anyway, but Judge Feldman was originally from St. Louis and had come to New Orleans, was very good friends with Scalia, and had pictures of he and himself with Scalia in his office, and Judge Thomas. And in fact, he had converted from Judaism to Catholicism as a result of both of them. So he was a very interesting guy, very hard-nosed. Knew Jason, though, and had known Jason because Jason had practiced in federal court and had an excellent reputation as a defense lawyer. And so it was really interesting in terms of the players that were involved. But Judge Feldman was hard-nosed and denied the motion after all the litigation that took place, and did not appear to be biased toward Jason in any way.
Yeah.
However, during the pendency of the case, he passed away, and we were a new judge was substituted after the case had been continued, and because of an interlock that was taken during the course of the case.
So about the pretrial motion about, the selective prosecution, because as you say, they're so hard to win. And in fact, in a lot of times, you file these motions and the judge says, not only are you going to lose the motion, but you can't raise this argument at trial. You can't even talk about these circumstances at trial. Were you allowed to talk, have that theme of political prosecution at trial, or were you precluded from doing that?
It's so interesting. It was so frustrating, David, because I remember thinking to myself, I can lose a motion to suppress, but I can still argue to the jury that this was not fairly done, that procedure and protocol wasn't followed. So why can't I do that on a selective or vindictive prosecution, right? So we were very frustrated. I will tell you, despite the fact that we could not argue it, and we did not, the jurors got it. They felt like there was total disparity going on. And let me be very clear, this jury was not an African-American jury. This jury was picked from outside parishes surrounding New Orleans. And many of them were very conservative. We did a deep dive on the jurors like you're supposed to do. And but they knew it. They could tell that there was something wrong and that he had been picked on because of who he was.
It's really interesting you say that, because just to use the trial that I just had with Andrew Gillum, we filed a similar motion. It was denied, and the judge also said we cannot mention politics, we cannot mention selective prosecution, we can't make those arguments. But we felt the jury got it too, and we tried to do it in different ways. I would ask the agent until the judge yelled at me, but I would say you would agree with me that it would be wrong to pick someone out for race or politics. And of course, the agent would agree with me on that. But and the judge said, I see what you're doing. You're trying to reverse it. Right. But it's crazy that we can't argue these things to a jury.
It was remarkable to me. And we had other ways of unindicted co-conspirators who had not been charged. And we had a tax preparer in this case who had held himself out as a actual certified public accountant and who was not, and who had pled, who was white and had gotten these breaks, and other defendants who had gotten breaks. So there was clearly a disparity there, and that was helpful to us. But I will tell you, this is when jury selection is so key. And as an African-American lawyer in this country, I look around this country and I look at the politicians who are targeted in this country. And for the most part, I think, wait a minute, why is it all the black DAs? Why it is Marilyn Mosby? And you see all the, your client, and you see that. And so, as someone of color, you have a sense that this is wrong. So how do I prove that, right? So during the course of this case, Judge Afric, who is the judge who was substituted in, and again, a very hard-nosed Reagan appointee, been on the bench for 25 years, and was not known as any easy friend, known as a very fair judge, but not someone who would be overly friendly to the defense. And I remember him telling me in the pretrial conferences, and we had Judge Feldman had allowed us to do a juror questionnaire. And he said to me, I just want to be clear, Ms. Wayne, I know you do a lot of jury selection and judges have given you even in federal court, but in my courtroom, that doesn't happen. There's no attorney conducted voir dire. So I never get, upset by when a judge says, I can't do something, right? Because I'm like you, David. I'm like, okay, but I'll figure out some way here to make this right. And we had this questionnaire, and I believe in, this concept of deselecting jurors. So I'm looking for jurors who have an attitude that is against my theme or theory of the case. That's all I care about. Not people who are friendly to me, but people who will never be open-minded to whatever the theory of the case.
So how do you do it? Because I'm fascinated by this, and you're the expert on jury selection. So how do you figure that out?
So in this case, I had really two questions. One was, most people in this country believe politicians are corrupt in some way. That's just true. I don't care if you're a Democrat, you're a Republican, you're an independent. Most of us have that sense, unfortunately, about politicians. So that was question number one. Mm-hmm. Question number two was, particularly if they are Black.
Mm-hmm.
And the responses to that question were, it was not surprising to me as a Black woman lawyer in this country, but very surprising to the white lawyers involved in this case. They were not surprising to Jason either, okay? But they were really ugly responses.
And so those were on your juror questionnaires?
Those on our juror questionnaires.
Oh, I can imagine some of these responses. I mean,
it was remarkable. And as a result of that, Judge Afric, and I give him a lot of credit for this, he was, I think, embarrassed that people from his state would make the kind of responses, and that it would clearly be unfair to Jason not to flush that out. So as a result, we ended up having 2 days of attorney-conducted one-on-one voir dire of every juror.
Wow, unbelievable. So the first judge tells you, you're not going to be able to do it, and not only are you end up able to do it, you get 2 full days of it.
Yeah, this Judge Afric, is the one who said that. Yes.
Oh, I thought it was the first judge who said.
No. And the first judge probably would have said the same thing.
Yeah,
but
they all do.
So, but the question was those were fair questions. So, I wasn't asking questions like, do you like the Nuggets or the Heat? Because we know that's going to be a question. I like the Nuggets, by the way.
We may need to end this interview now.
I'm from Colorado. Come on.
I know, but let's go Heat. So tell me.
So, it was really drilling down on questions, and people, lawyers always say to me, but I don't want to ask that negative question, but it's the negative question that's the response I need to know, right? I need to know how you really feel. And to me, the bad answers are good answers for me. I can then intelligently use those preemptories.
So do you have a jury consultant with you, or are you doing this all on your own?
I don't use a jury consultant because I am grateful that I seem to have good instincts. I've actually helped other people and done a lot of mock jurors. Now, that's not to say there aren't great people like Denise DeLaRue. I think Denise has incredible instincts, and I've used Denise on a lot of cases. Joanne Coonan. I mean, there are good people out there, but I'm that kind of lawyer.
Yeah, you do it. And it's funny because, I was a public defender, and then I was a lawyer for many years with clients who could not afford a jury consultant. Now, a lot of clients that I have want to spend the money. They're looking, let's do a mock jury. Let's have a jury consultant. And there are benefits. I mean, when we do a mock jury, it's wonderful, but I'm used to asking the secretaries, what do you think about this guy? That's, and using the old PD ways, but lots of clients now want to spend that money and have consultants around.
And I understand that when you are under such an awful power of the government making an accusation against you, if you have the money, you want to put everything you can to save your life. That makes total sense to me. We have figured out ways, David. I mean, one of the things that to me was a silver lining about COVID is that Jason didn't have money. By the way, he's a public official, so he didn't have money. And people are like, how much money did you make on that case? And I'm like, really?
Yeah.
The things you do in your life because you believe in them, frankly. And so that was that kind of case. There wasn't great money, but we did mock jurors by Zoom. And we use the concept of, we put out feelers in a geographic area that was very similar to New Orleans. We did it on Craigslist. We did it on a number of other things. And we did it on Zoom. And it was actually pretty good. And we got some good sense of who we didn't want on that jury. It was valuable to a certain extent. It really was.
Really, really interesting. When you do these cases with local lawyers, let's just use the example of picking a jury. Do you guys pick by, sort of consensus? Do they defer to you? I mean, how do you do those things? I always find it hard, like doing with a team of people. Edward Bennett Williams always said, we can have a team, everybody gets one vote, and then I get all the votes plus one. So how do you do it?
I agree with you. I have been so lucky. So again, Billy Gibbons was my co-counsel on the case. Couldn't have done this without Billy. Billy is a fantastic lawyer in New Orleans. Mike Magner and Avery Pardee represented the co-defendant, Nicole Burdett. And because I've done cases with them, they totally trusted me. And, I did a case with Mike Magner, a doctor we represented in New Orleans. And I'll never forget it because Mike, was an ex-AUSA. And when we were at halftime on the case, and I'll never forget being in the kitchen of the courtroom in a small space behind chambers, telling him, we are not putting on a case. We are not putting on the client. And that was a hard one. I will never forget it, but Mike trusted me. And so you have to have a sense of real trust with your colleagues. And I've been very lucky, and again, I have a proven track record. So it's not like I'm a new lawyer and you're trusting me, but he trusted me and I was right. If I hadn't been, trust me, those are the days where you're like, what if so same thing happened with Jason. Everybody, we came into that case saying, if you're ever going to put anyone on the stand, the expectation would be a politician, someone who has been elected, someone who is eloquent and persuasive, and someone who is a lawyer. You're going to put that person on the stand, right, to tell their side of the story.
Absolutely. And so how do you make that decision? You're jumping ahead of me, but this is, I want to talk about this. So, obviously everybody's expecting him to testify. He's the district attorney. How do you not call him?
That's right. And I'll never forget Billy looking at me and I was like, they have not proven this case. We have taken apart the government and dismantled their agents, their main witness. They made some real missteps, evidentiary wise, and they didn't have proof beyond a reasonable doubt. And I am a huge proponent of the reasonable doubt instruction. I'm a big advocate of it. The Fifth Circuit has one of the best, surprisingly.
Yeah.
And I said, there's just no way that a juror would not hesitate on this case.
So do you have him prepared and then you guys make that decision, or did you go into it thinking he would not testify?
No, we went into it thinking he would testify.
He would testify.
He was prepared. We had obviously spent all the time that you do. The great thing about when I was a public defender, we didn't have the computers that you could practice, and so now we can do the practicing, right? You just hit your Mac and go, okay, let's practice this. And we were practiced. But with Jason, again, this is a guy, if you go on Instagram or anything and you watch his speeches, he's one of these eloquent speakers that you go, I believe you. I mean, you're raising your fist up and you're going, I'm with you, brother. And he's that way. But I just knew that there were speeches that he had given, things that I could see getting taken out of context. I don't care how innocent you are, you can be made to look suspicious, right? We know that.
So it's so true. And something I think that has gone away. People have gone away from reasonable doubt, have gone away from clients not testifying. There's a trend towards clients testifying. There's a trend towards lawyers saying, not focusing on the reasonable doubt instruction. So, those are sort of first principles we learn as defenders, and it is weird to see them sort of going away.
It is, and it's troubling to me. So I gave I was in San Diego at the Federal Defender Seminar a few weeks ago, and one of the things that I said to the audience, not to myself, is that I have a lot of respect for this ever-evolving holistic approach, where we are more in tune with our clients, that you have social workers and you're getting the background and this narrative about your client. But don't forget why you became a lawyer. Don't forget it's about drilling down on the legal issues and challenging the government and constitutional principles. Do I love the underdog and what I do? Absolutely. But that's why I became a lawyer. And I think we are losing sight of some of that. And it's great putting your client up, but I have to tell you, And all the case trials I've had, David, and you probably feel the same. I've had over 200 jury trials in my career. I've probably put a client up 4 or 5 times in my lifetime. And
Wow.
I've won a lot of those cases.
Yeah, yeah.
Client. And I was practicing in a conservative jurisdiction. I'm in Colorado. Denver is progressive, but you get up in the mountains, you go up to the Eastern Plains. It's no different than going to Tallahassee. Okay.
Right, right. Right.
So,
So how do you deal with that in closing then? Your client doesn't testify. Obviously, jurors and other people are expecting that a politician, especially a district attorney, would. What do you say in closing? What's your standard spiel?
I don't have one. You know that. I don't have a standard spiel at all. I don't believe in that. But I will tell you, I write out things. I'm very much the OCD lawyer,
Yeah, me
writing it
too.
all out. But I never ever use a piece of paper. Oftentimes, things change and it's fluid in trial, and you have to be able to respond. So the AUSA, when she got up and finished her hour-long closing, I had a PowerPoint ready and I had the financial documents and all the highlights, but I stood up and it was completely off the cuff. I'll say is that I looked at the jurors and I took a moment and I said, I feel like she wasn't even in the same courtroom.
It's
I feel
great.
like wasn't even listening to the same witnesses you heard from. And so I started from that point. And the judge said to me, he said, when you did that, I was like, right on. That's what I would say.
That's awesome. That's awesome. I love that. You have to be flexible. You have to be willing to sort of react. In the Tallahassee trial, my partner Margot gave this wonderful opening, and she had worked on the PowerPoint, like you say, worked on, written everything out. And the government got up and started by saying, this is a really complicated case, and there's not going to be a smoking gun. And, Margot started her opening by saying, there's not a smoking gun because he's innocent. And this is a simple case. She sort of threw away the notes and responded. And it's so you have to be willing to do that.
Absolutely. And it sounds like Margot is exactly the kind of lawyer I love, because opening, and I know people argue about this, but the social science is pretty clear. 80% of jurors make up their mind after opening. Then they marshal the evidence to fit the side that they've taken. We all do that in life. So that makes sense to me. So opening is so important. We all love closing because it's, you get up there, it's the end of the, trial, and you can do all the things that, the flair and everything else, but it's really opening. And so when I hear someone being a bit on that, argumentative side, which whenever a judge stops me and says, you're arguing, I'm like, well, I am arguing position here.
Yeah, no, I agree with you. You win the case in opening, and she won the case in opening. There's no question about it. And I think opening is a million times harder than closing too, right? Because it's so stressful. It's the first time you're getting up. The jury doesn't know you yet. You don't know how the evidence is going to come out. So there's all these strategic decisions about how far you're going to go, what you're going to say. So I think opening is really, really hard. And the most important part of the trial.
It totally is. I'm just so glad we're talking about it. And look, people say that it's hard, and this is the law professor part of me, is that I'm always like the undisputed facts. So take those undisputed facts that nothing can change. I don't care if a witness flips or not during trial, you have it from prior testimony or whatever. And that's the architecture of your opening statement. And if you go in there, you'll feel so much stronger with those undisputed facts, and being armed with them. Yeah, things change. I mean, that's what we love. I mean, don't you love when the government's witness suddenly says something, you're like, well, that's brand new.
Yeah, no, they go south. I love it.
Did they know about that before?
Right. But what about also, and to get back to your teaching, the themes, trilogies, those kinds of things that we learn about. What was your theme in the case?
I knew you were going to ask me that. It's so funny because it was a good faith reliance case. I mean, he relied on the advice given to him by his accountant, and that the focus of the case was this accountant not only had held himself out as a CPA and someone who was reliable to Jason, but had lots of other people who had never been indicted. And guess what? They were white.
Mm-hmm. Mm-hmm.
Um,
It is
and
hard to make a good faith defense, Lisa, when the guy you're relying on is testifying against you. I mean, that's not an easy defense.
I know, and our client was a lawyer, so we had to be careful that there wasn't an extra burden of, boy, you're a lawyer, don't you have another level of like making sure whoever you're using is a CPA or whatever it is. But in this case, it was interesting. So the co-defendant in the case, Nicole Burdett, who was actually found guilty on separate counts on another indictment, but they were merged together for the purpose of trial. It was a family. Friends had recommended this guy. So there had been reliance as a result of that. Nicole was a lawyer in Jason's office who had been a friend of his for a long, long time, had worked his campaign. So there was no reason to question that. And the other hard part about this, and we know this, David, is Jason ran a very small boutique firm. He was busy, and really he's the kind of lawyer who never paid attention to details. And he was in and out of that office, relying on his office manager, the associates in the office, and going to court, being a city council person. And so that was something we were able to bring out, that there was just no reason for him to hide anything because he was relying on others. And that's the sole practitioner's world in so many ways.
It is. But that said, it's always really tricky when the guy you're relying on is pointing the finger at you. So when you're going after this guy, what's the attack? That he's lying to save his skin? What is the attack on the snitch?
Well, it was really interesting because it was a buildup. So, it's always hard on cross. Do I come in and I'm slamming that person immediately and I have this tone of going after, or do I try to garner some trust so that I can lead them to the place I need them to go? I like the second tactic a little better because I just think we lose credibility when we're on the attack all the time. It's hard. I remember as a young lawyer, right? I was on the attack all the time because that's just who we were. So with this, with this particular witness, it was, you did these things. You held yourself out as a CPA. You did that because you'd been practicing a long time. You hadn't thought about it. You didn't know when you were putting on your letterhead and holding yourself that it might be, all of these things, really building up how he had the trust of the community and so many others that there wouldn't be any reason for Jason not to have trusted him. And there was also, Jason actually never met with the guy. It was everybody else who was meeting with it. It was literally Jason signing the dotted line.
How do you learn to do this? So one of the things that I like talking about on the podcast, because, so many lawyers listen and we all want to become better lawyers. How do you learn how to cross a guy like this? How do you learn how to give an opening or a closing? I mean, you're obviously running NACDL now, so it may be a good time to pitch becoming involved. But even becoming involved, I mean, how do you get better?
David, I think it's trials and experience. I was a public defender for 13 years in one of the best public defender systems in the country in Colorado. I mean, we were well known for the training that went on there. Sunwhoop was one of my mentors. I mean, Larry Posner taught me how to cross. He was in the Colorado system. That's how you learned to cross, was the chapter method. So I didn't know a different way. Trilogies and all of that were just part of my DNA. So I'm really grateful, and in many ways I'm lucky. And it took to who I am. So, I can't help but thank my mom, because my mother is a people person and she has great instincts, right? So I had a mom who, you can go to Whole Foods with Juanita, that's my mother's name, and she can tell you 100 things about the clerk that she learned in 20 minutes.
It's like my dad, same kind of person, but we all need a mom like Lisa's mom. But you mentioned, I have to tell this story. So you mentioned Sunwolf, and not many people probably know who she is. She's this wonderful woman who I heard lecture when I was a young public defender, and I was taken with her and her techniques. And I had learned one thing from her that I was dying to use, and I finally used it in Andrew Gillum's trial. She said, if you're looking to embolden jurors, they're going to elect a 4-person, and one thing you can tell them is, don't let the 4-person eat up all the time in the jury room. Turn to each juror and say, you may want to address the issue of why there are no fingerprints in this case. Then turn to the next juror. You may want to address why there's no DNA in the case, and go through all the reasonable doubts and tell each one to be the 4-person on that. And so in this case, we knew we had some jurors going into deliberations. And so one of the things we did in closing is I said, I use that Sunwolf technique, like, don't let your voice go away in that jury. Make sure you stand up and get heard. And we looked sort of at the jurors that we thought were supporting us when we said that. And I was thinking of Sunwolf that whole time.
You know what? I'm going to have her listen to the podcast because she's going to love that. I mean, she not changed. She had an impact on so many lawyers in this country. And if you get her, it is incredible. So, the Juror Bill of Rights, deselection is really from Sunwolf. Okay. It's out of the Colorado method that comes from Sunwolf. And so she's just brilliant. And the last thing I heard her lecturing in the San Francisco Public Defender's Office a few years ago, and she's still doing this, is that she said, we used to care about jurors' responses about, how do you feel about this? And how do you do this? And all of that feeling thing. But really what matters, and this is so great, is the conduct of the juror. So if I say, I believe in DUI laws, I believe in those. Tell me what's your conduct that's consistent with that belief. Mm-hmm. Have you ever seen someone on the road who's, weaving and called the police? Have you ever called an Uber for somebody at a party because you knew they were under the influence? It's the conduct more than that saying the belief. Think about, doesn't that give you goosebumps?
She's something else. No, really good. Really good. Maybe we should have her come on. So let me ask you, Lisa, so you have this co-defendant and you've mentioned, ultimately what happens. Are you guys working together at the trial? Are you sort of teamed up, or are you trying to separate yourself from her during the trial?
No, it was definitely a mutual thing, and it was very difficult. Jason was the target. She was the collateral consequence.
Yeah.
And it was, so, I was more of the one in there, but, when you got someone like Mike Magner and Avery Pardee, no one's going to be quiet, right? So Mike was in there on a lot of this stuff, and Avery was the motions, and she was just brilliant. I just couldn't have asked for a better team, but, it was really hard when Nicole went down on the other indictment, and it was very difficult. And so that sentencing is still pending.
Let me ask you about that. So the jury goes out. How long is the jury out?
It seemed like 100 years, but we sat in the federal defender's office and Claude's office. Thank goodness for, defenders are united everywhere. They let us use their offices as the war room. It's right there in the courthouse. And I think it was 2 days. It may have been longer, but I think it was 2 days.
Worst part, right?
I know. Isn't that funny how I completely repressed how much time it was?
And before we get to when they announced the verdict, one of the things that I was reading about the case is that you guys had to use different entrances and exits because of what was going on and threats. What was going on with that?
So the second day of trial, the FBI comes in and lets us know that there have been threats that they believe are, honest to goodness threats from the right. And I guess they can pick up some of these people, who are on these threads, these white supremacist threads, and that they recommended that Jason wear a bulletproof vest. Crazy. And so, that throws more stress into a trial, particularly for someone who's accused. And so Jason had to wear a bulletproof vest. I wasn't going to. My vanity is too great that that was not going to happen and add 10 pounds to me during trial. But he wore one, and he had to go out through the judge's special entrance. And we went out, we would always avoid the press. The press, was camped out, the deal, all day long, every day, just in case. I mean, the funny thing is I stood up and said the defense will rest based upon the government's evidence, the press went. I mean, you would have thought the Third World War had been declared. They ran out, and it was unbelievable. But so we used separate interests. So that hung over our heads, and it was scary. My husband was not happy that
I bet
I was standing next to someone who might be a target all day long, every day. But we have to not be afraid, and I mean, I have to say, defenders are courageous people for the most part, and we get threatened because we represent people who are, the despicable in this country, the despised. Nobody likes you, and we're brave people, David. I think
it's so true. And Lisa, I talk about this all the time. This is the one job where everybody's rooting against you. The judge is rooting against you. The prosecutors. The jurors come in thinking, I want to root for the government. The public, the press, everybody is rooting against the criminal defense lawyer. It's really hard, and I don't think people realize what we go through sort of on a day-to-day basis.
I know. Why do we do it, right? I mean, people say that, and nothing's better, though. I mean, nothing's better than when you turn that, that corner, and they're all finally looking at you like, whoa, actually, she's the truth teller. Whoa, actually, she's on our side, right? And nothing's better. But, I think through my career, I've had some doozies of clients with some horrible allegations. And, I remember being in the courtroom as a young lawyer at one point going, and the DA is standing there in state court, pointing their finger, just he did this and he did, and I had to remember, okay, he's not talking about you.
But
you're going home.
Right. You say, why do we do this? I think all of us are a little sick to keep wanting to do this over and over again.
No, I don't think we are. You know what? I think we are really incredibly gifted people who have taken a gift and decided to do right by it. I really do, David.
Amen.
And, when you're people like us who come from historically racial and cultural backgrounds where our people endured, it's a natural thing for us, right? Mm-hmm. This is a natural extension of where we should be. When I look at my son who says, I don't want to have anything to do with what you and my dad and my stepdad and my grandparent, I don't want to do that. And I go, wait a minute. This is like voting, honey. Our people fought to get to the voting booth, and you need to be here fighting. Now, you can do it in a different way. You don't have to be a lawyer. I get it. But yeah, I don't have a second of regret.
No.
And I remember, I don't know how long I'll be able to be out of the courtroom, David, but I remember, when I'm in trial looking in that mirror, even when we're getting beat up and someone's been sentenced to life. I've had those, and thinking to myself, but I'm doing the right thing. This is the best job ever. Right?
So true and so great. And so you come back, you get word that the jury has a verdict. And I saw that the first verdicts that are read are your co-defendants. You must have been absolutely dying when you hear the co-defendant guilty verdicts.
It was such an interesting experience. So in this federal court, I've never had this, and I think they're all different, but there was the judge is elevated above us for those who are listening who've never been in these federal courthouses. So the judge is elevated way above us. Then there's another elevated where the court reporter and the clerk sat, and they have their computers. And the judge brought in a special microphone and handed the verdict forms to the clerk. She pulls up this mic like she's going to bust out in a Tina Turner song, and I'm saying that because
yes,
she has passed, and starts reading these verdicts, and we all are standing up. So I have Jason next to me, and Billy is on the other side of Jason. Now you have someone who has been a defense lawyer, someone who is now a DA, is now a defendant, looking at his life being completely taken away from him, going to federal prison, losing his law license, everything, right, that he has worked for. He is shaking like a leaf. And Jason's a big, strong, a strong, in shape guy, right? I think to myself, if he goes down, he's taking me with him. So I grab under the table to hold on.
Wow.
And Billy, I can't look at Billy, who I know is feeling the same way I am. And they start reading Nicole's verdicts. And I'm like, oh no. But they're reading through the tax counts and it's not guilty. So it's only her other counts, and she's not charged with the 8,300 counts. Everybody says to me, you're never going to win 8,300 counts. Nobody ever wins those. But we had some good defenses on the counts. It was just wrong what they did to him. It was wrong. And so when then they start going through, you know the deal. You can't celebrate till the end, right? And there's like, I can't remember, 15 counts. So it was a long, horrible time. And once it was done, it was literally sitting down and breaking down.
I bet. And you hear those 2-word verdicts, and it's like not only a weight lifted off, it's the flood of emotions. It's for people who have not been through it, it's hard to describe.
It is hard to describe. And this is what's wrong with us, is even when you win, I don't know if you do this, David, I still, when I think about the case for like a week later, about things I should have done differently.
It's bizarre because we don't savor the wins like we should. And even celebrate them like we should. That's part of the reason I'm trying to do this podcast, because I want to make sure that we talk about these things. Do you get a chance to celebrate with your client that night? Or
so we did celebrate. A couple of things happened. So we went back to the federal defender's office. We weren't going to talk to the press. And I had put a kibosh on that. Mike talked to the press, but that's Mike, and he knew how to do that. I don't believe in it. I just don't like it, even though I have worked at CNN and done all of that. I just don't. They're no friends of ours generally. That's the rule of thumb. Okay, they're not looking to help the defense.
That's true.
So even though we had won, I was like, so we're sitting in with the federal defenders, and I think Claude, who's the federal defender down there, may have had like a bottle of bourbon. I don't drink hard liquor. And, we were all drinking bourbon. I think I might have had a sip. I was looking for a beer. And at one point, Claude and another defender, and I can't remember, but said to me, you really ought to go out and talk to the press. And I go, why? They said, because you know what? You're a Black lawyer in a predominantly Black city with a Black DA who they elected. You need to go out and talk to them. Mm-hmm. And that hit home with me. And that's why I went out and talked to the press. It was because of that. And they were right. I had friends who were in hotels. Lori Towns, actually, who's the executive director for NAPD, was in a hotel. She said when the verdict was read, all the Black workers were around the television and we're all cheering.
Wow, what a great thing.
So it was a significant thing for them in that city. And the fact that I wasn't really cognizant of it until someone told me. And I'm glad I wasn't, because that would have been a great weight on my shoulders, greater than everything else. All right. So that was wonderful. And then one of the restaurant owners opened up the restaurant. We had a big party, and there were a lot of people that came and were very happy for him. Then I flew back to San Francisco to home to see my husband, who I hadn't seen in a few weeks, and I got COVID.
Oh my God. What a great way to celebrate COVID. But at least you got COVID after a win. I mean, getting COVID after a loss would have been the worst. So
we were beat up. I mean, it takes a toll on us. I mean, it's a big toll on our bodies. So it made total sense to me that was the first and only time I had gotten COVID. And I thought, okay, I'm letting down now here.
Of course, I get sick after every trial, win or lose, because you just let down and then you get sick. Yeah.
That adrenaline.
Well, listen, I want to thank you for doing this. It's so great to hear, this story, and thank you for all that you do for criminal defense lawyers and our bar, because we need more Lisa Waynes out there.
Well, I think that's great. And I'm glad that you feel that way about me. And, look, NACDL is trying to do a lot for us in terms of the teaching that you talk about, all of that, David. And one of the big things is trial penalty that we talk about. So when you talk about, how are lawyers going to get better and openings and all of that, we are not in a place where we are challenging the government enough because we're so concerned with the hammer, the consequences that if individuals exercise their constitutional right to challenge the government, you are going to be punished for that if you go down, more so than if you took a plea. And so then there's a disappearance of trials. So we have to really stand behind this issue and really change it up, David. This is the gift we're going to give younger lawyers, is we've got to change that path.
I'm so grateful that Lisa Wayne took the time to discuss the Jason Williams trial with us. It's so inspiring to hear those sorts of stories, and brings us back to the first principles of being a criminal defense lawyer, trying cases, all the techniques that we have. And I think it was good just to remember some of the importance of beyond a reasonable doubt, opening statements, things like that. And it's one of the reasons we get CLE credit for these podcasts. If you're in Florida, we just applied for it and received it. So at the end of the season, you'll be getting CLE credits for these episodes. So I want to thank Lisa Wayne for participating. She's wonderful. And again, please get the word out for these episodes. Thanks so much. And we'll be back in 2 weeks for the defense. Thanks.